This criminal law and procedure question gives us a chance to confront a number of difficult issues. This is a complicated, long fact pattern. This is a question that could well serve as a 90-minute or 2-hour final exam question. But it's actually a bar exam essay question, and you'll see language just like this on the multi-state as well. As always, both for essays and for the multi-state, we start by having a look at the call of the question. And we look at it. How should the appellate court rule on claims made in Deft's properly filed motion for post-conviction relief that, 1. Len gave him erroneous advice when he told Deft there was no meritorious basis on which to seek pretrial review of the denial of his motions. Discuss. Well, we're going to have to look at the facts to be able to answer this question, but just up front, we look at this call and we think maybe we ought to consider each motion separately. Then again, maybe it'll be easier to consider them together. Call number 2. He had potentially meritorious defenses of insanity and diminished capacity, which Len should have presented. Discuss. Well, here we call up our checklist of the various types of insanity defenses, and we prepare ourselves to connect the facts from the pattern with each of those insanity defenses. And remember, the most common mistake folks make on insanity questions is they blank out and they forget one or more of the defenses. That's a list you need to memorize. 3. His plea of guilty was not A. shown on the record to be voluntary and intelligent, and B. in fact, was not voluntary and intelligent. Discuss. Again, we're going to have to look carefully at the facts and judge them against the standards. And one also would think that if we've got a defendant who may have had insanity defenses, it's possible that that defendant would have lacked the capacity to enter a plea of guilty. Then, question 4, Len's conduct of the defense denied Deft constitutionally adequate representation. Discuss. One thing we can say for sure, this is not a PR question. This is a question about criminal procedure. And the Sixth Amendment does require that an attorney have some minimal level of competence. And we'll take a look at the facts here. Ultimately, this is one of the fairly rare instances in which a defendant should have a fairly compelling case against his or her lawyer. Now, let's go to the top of the question and take a look at what happened. In paragraph 1, we meet the defendant. He's had a long history of mental illness. He became enraged with his landlord, who threatened to evict him over non-payment of rent. Deft picks up a baseball bat, hits Vic over the head with the bat hard enough that it stuns the victim, and it gives him a concussion. The defendant immediately exclaims, "I'm sorry, Vic, I didn't mean to hurt you." Well, let's just pause for a moment. Assume that the defendant does have mental capacity for a moment. Assume he's not crazy. What crime has he just committed there? He has committed an assault with a deadly weapon. He's committed battery. And one could argue, given that a baseball bat could easily be a deadly weapon, that he's attempted to murder the victim. Now, immediately after the act, he apologizes and he says that he didn't mean to kill. That may be evidence that this guy is, to use a clinical term, crazy. Turn to paragraph 2. Based on those facts, he is indicted for attempted murder. That's the harshest charge that he could face from those facts, but it's not counterintuitive. It is very much what a prosecutor could reasonably be expected to file against somebody that hits a victim over the head with a baseball bat. Bail is denied, but this is not a question about the Eighth Amendment and how it has not been applied to the states. At Deft's first court appearance, Len is appointed to represent him because he is indigent. He enters a plea of not guilty and a plea of not guilty by reason of insanity. The hearing, where the magistrate orders the defendant held for trial, the lawyer, Len, moves for dismissal on the ground that the charge before the magistrate did not establish probable cause, and secondly, for appointment of a psychiatrist. The court denies both motions. Well, taking a step back, the court's denial of the first motion probably was valid. because the defendant's use of a deadly weapon to strike the victim really is good enough to establish the basic prima facie case elements of attempted murder. Certainly there's probable cause to try a defendant who has done that act for that charge. But the magistrate's denial of the motion for a court-appointed psychologist is certainly a mistake. And the Supreme Court has held that an indigent defendant who wishes to present an insanity defense has got a right to a court-appointed psychiatrist. Now we go to paragraph 3. The defendant asks Len to seek immediate appellate review of those motions, and we know from the facts that that review was available. Len refused to do it, telling defendant that he didn't think there was a meritorious reason to do so. And we know the lawyer's wrong about that because there is a meritorious appeal on the basis of for the denial of the psychologist. Now, the defendant is discouraged and he's frustrated by the fact that he's still in custody. He accepts the lawyer's suggestion that he plead guilty. And the lawyer assures him that if he enters a guilty plea, he's going to get time served and released. And here, the lawyer's representation of this defendant is on very shaky ground. He's basically forcing the defendant to plead guilty and failing to pursue absolutely legitimate avenues of defense. So, the next paragraph, defendant comes to court again. The lawyer advises the judge that the defendant wants to change his plea from not guilty and not guilty by reason of insanity to guilty. The judge only asks one question. Is that what you want? Defendant says yes. The judge allows him to change his plea and sentences him to 5 years in state prison as opposed to giving him time served. Now we've got the call of the question again. This is quite a straightforward question, and it's a question for which there are correct answers. So turn the page. Take a look at the way that I have organized an answer to this question. It's very straightforward, and it would be a good platform upon which to write a well-organized, thorough, accurate answer. So the first call of the question asks us about the pretrial review of the merits of the defendant's motions. There are 2 motions. We'll talk about each of them separately. The motion to dismiss the charges was properly denied because the defendant's use of a deadly weapon and the testimony about the physical assault by the defendant on the victim is enough to establish probable cause to try the defendant on attempted murder. But the second motion, the motion for the appointment of a court-appointed psychologist, was improperly denied. An indigent defendant with a reasonable cause for presenting an insanity or diminished capacity defense has a right to a court-appointed psychologist, and the court's failure to make that appointment is an error. So, ultimately, we conclude the court's denial of the first motion was justified, the court's denial of the motion to appoint a psychologist was not. Then, we turn next to the insanity and diminished capacity defenses. And here, as is the case many times, we're basically just being tested on our ability to remember what they are. So let's go through the laundry list. The first insanity defense is the Durham test, which basically is the product test. Was the defendant's conduct the product of a mental illness? In this case, the answer is very possibly yes. Certainly there was a valid Durham defense that should have been presented. Next, we consider Mcnaughton. Here, the test is that the defendant didn't know or didn't understand what he did. And here again, the defendant's got a fairly compelling defense that he should be able to establish a Mcnaughton rule, insanity defense. Next, we turn to the ALI, or Model Penal Code test. Here, we've got a defendant who has to be able to show that the conduct was the result of a mental disease and a lack of substantial capacity either to understand the nature of the conduct or to control it. Here again, the defendant probably could establish this defense. Finally, the irresistible impulse defense appears almost to be defined by this defendant's conduct. Certainly, he had a meritorious defense, at least arguably, under the irresistible impulse test. So, on the merits, based on the defendant's prior history of mental illness and based on the facts that we're aware of in this case, there's a very good chance that this defendant did have persuasive insanity and diminished capacity defenses that he should have been allowed to present. Third, we turn to the defendant's guilty plea. We know that the record of the guilty plea was defective because the judge has to go through really chapter and verse making sure that there's an explicit record, that the defendant understands what he's doing. That means he's got to stipulate that he is liable and guilty under each element of each charge. He has to stipulate as to his mental state, both with regard to the offense and with regard to making the decision to change his plea. All of these details about the voluntary nature and questions that show that the plea is intelligent must be made on the record, or else the record is inadequate and the guilty plea has to be thrown out. So, with regard to the first element of question 3, the record's no good, that's for sure. Now, how about the substance of the plea? Was it knowing and voluntary and intelligent? Again, the clear answer is no. This is a defendant who has pled guilty as a result of unreasonable pressure by his attorney and by his attorney's failure diligently to represent him in this case. So, in fact, the plea of guilty was neither voluntary nor intelligent. The bottom line, pretty much throughout, this guilty plea is invalid. It was invalid in substance, and it's invalid on the record. In other words, we ought to tear it up on appeal. Next, we turn to question 4. Was the defense lawyer, Len's, conduct of this case so weak as to violate the Sixth Amendment? The short answer is yes. And a question very much like this also could be framed as a PR question. Does this lawyer's conduct fall short of his ethical duties? And the answer again is yes. This is a lawyer who has fundamentally failed zealously to represent his client. But this is not a question about PR. It's a question about con law. Does this lawyer's conduct fall short of what the Sixth Amendment requires? Answer, yes. This lawyer did not zealously represent this client. He failed to pursue a potentially successful insanity or diminished capacity defense. He pressured the defendant into pleading guilty, representing to the defendant that he would receive time served, when in fact the defendant received a 5-year state prison sentence. Taken as a whole, the conduct of the attorney falls short of constitutional standards. And that wraps up a consideration of a difficult and complicated criminal law and procedure fact pattern. This is one that gives you good mileage for the time and effort you put in. It covers a lot of good issues.